Hello and welcome back to Coin Matters channel. Concerns were made concerning the XRPL memos for banks and governments, and the Ripple CTO addressed those issues. CTO Ripple David Schwartz responds to a member of the XRP community who expresses worry over the potential abuse of memoranda on the XRPL by financial institutions and government agencies. Mr. Intuitive, a media celebrity, expressed his worries regarding the use of memos in the XRP ledger XRPL in a thought-provoking Twitter exchange with David Schwartz, the CTO of Ripple. When dealing with financial institutions and government agencies. Before I go into depth, I ask that all members of the Ripple family please like the video, subscribe to my channel, and enable notifications. If you want to see XRP increase, subscribe and enable bell notifications. We have a solid group here. In his first tweet, he asked followers to use the hashtag #RippleXRP and to encourage engagement in order to help Ripple XRP expand. Mr. Intuitive made the suggestion that widespread adoption of the XRPL by financial and governmental entities would be beneficial. Any user can currently add a note to a transaction that involves another user, which could cause problems. This observation was made in response to a mysterious note discovered in one of Ripple's escrow deals just recently. Mr. Intuitive's concern was around the risk of malevolent actors adding harmful or fraudulent documents to transactions, which might in turn associate the targeted banks or governments with undesirable content. In response, Ripple's CTO David Schwartz emphasized that the XRPL functions regardless of the identities of the parties engaged in a transaction, meaning that banks, governments, and other organizations are all treated equally. He pointed out that memoranda can be attached to purchases by anyone, regardless of status. He went on to say that anyone, under the right circumstances, could polish off an accounting entry. Schwartz referenced a recent occurrence to claim that a member of the XRP community had been the first to clean up one of Ripple's expired escrows. Schwartz may have provided an explanation, but Mr. Intuitive is still insistent on proving his case. He re-emphasized that even while the ledger is not required to be aware of the entities involved, any party's misuse of memos could lead to unexpected consequences. If the XRPL were to be widely adopted by organizations like banks and government agencies. In light of Mr. Intuitive's criticisms, David Schwartz linked Mr. Intuitive's tweet to the outrageous claim that Val Kilmer's best film was an example of actual genius. This lighthearted answer exemplifies the fact that not all memoranda warrant serious alarm. To drive home the seriousness of the situation, Mr. Intuitive stresses that while jokes about favorite movies might not cause alarm, tagging his tweet as racist would cause him real concern. Frightening Memorandum LDRD, a respected member of the XRP community, has stated that Terra judge's comments on the Ripple judgment are superfluous, muddled, and not legally binding. The chief legal officer of Ripple's has provided some context for the judge's decision in Terra. It is worth noting that Judge Rakoff's comment on the Ripple decision has been a major topic of discussion within the cryptocurrency community, and that Ripple's chief legal officer, Stuart Alberti, has provided additional insight into the recent ruling on Terraform Labs, in which a federal judge rejected Judge Annalisa Torres' distinction of XRP sales out there. Judge Rakoff's comment has put the Ripple judgment in serious jeopardy, according to former SEC officer John Reed Stark. Interestingly, in the wider world, he thinks the Terra case doesn't affect the Ripple decision. This is what Al Verity says. The Terra judge's remark on the Ripple decision is superfluous, muddled, and not legally binding. After reviewing the Terra verdict once again, the famous attorney made his opinion known. In addition, the Terra judge ruled that mutual consent from the contractual parties is required for an investment agreement to be valid. Finally, the judge agrees that tokens alone do not constitute securities if they are not bundled with other commitments and rights. According to yesterday's news, Judge Jed Rakoff, who was presiding over the SEC v. Terra lawsuit, rejected the defendant's move to dismiss the case. I'll make some snide remarks as this development unfolds. Despite the company's attempt to use the earlier verdict as a precedent, the judge denied the motion. The judge ruled that the means of selling cryptocurrency should not be treated differently. Notably, the development caused a dispute within the crypto community, forcing LDRD to address the confusion. A tweet from the day before. He claimed that the fact that XRP is not a security still stands notwithstanding Judge Rakoff's failure to adopt the logic of his colleagues. Despite the regulatory haze, XRP shines. The future of Ethereum is unclear. An important judgment in the crypto legal saga has reignited debate over whether or not Ethereum ETH and Ethereum are actually legal tender. Hod's case, which sought declaratory relief on whether or not Ethereum and Ethereum DCS are securities, was thrown out of court. The ruling's lack of regulatory clarity has serious consequences for Ethereum and the whole cryptocurrency ecosystem. However, Ripple's XRP appears to be the only cryptocurrency with any sort of legal clarity in this chaotic environment. A procedural dismissal of the unrest in the domain of Ethereum. Hod Allah had filed a lawsuit to clarify the SEC's position on Ethereum. However, the court dismissed the complaint on procedural grounds, citing Hodilla's lack of standing to proceed. This conclusion added to the ambiguity that had always existed. The court's ruling has nothing to do with the substance of the case, but rather with technicalities of the case's handling. It mentioned that the SEC has looked into HODL law or threatened to do so. The court ruled that Ethereum is a security notwithstanding HODL law's concerns that the SEC poses an urgent threat because to its ambiguous stance on Ethereum. Concerns in the legal and cryptocurrency worlds have been heightened by the SEC's continuing quiet on Ethereum. HODL law contends that the SEC's intransigence on the matter indicates that it considers Ethereum to be a security and is simply waiting for the proper opportunity to act. Although HODL laws claim that the SEC has formally ruled that Ethereum and Ethereum DCS are not securities, the court found that the presented papers, including the hem and speech, did not support this assertion. The judgment highlights the pressing need for the SEC to give comprehensive guidelines rather than addressing concerns in piecemeal litigation. Users of Ethereum feel unsafe because there is no clear direction for them to follow. The court's decision implies that pretending Ethereum doesn't need to comply with regulations constitutes willful blindness. And after the dust settles from the court verdict, Bill Morgan's clarity on the XRP position. Attorney in Australia who is passionate about digital assets, Bill Morgan pointed out that only XRP from Ripple has a clear legal position at the moment, adding that Ethereum's legal status is still unclear and that it may soon be targeted by the SEC. When he said that standing was an issue, I agreed with him. Your quoting of the proceeding and the judge's comments demonstrates that #Ethereum has lacked legal clarity and may be a target of the SEC. For the time being, XRP is the only cryptocurrency with established legal status. Please consider subscribing to my channel and giving the video a thumbs up if you enjoyed it. See you soon, bye.